I'm Bruce Tuff, principal of the Tuff Law Firm. We are a full-service law firm serving the greater Woodlands area and the greater Houston area. Contact us at 281-681-0808. We're tough for you.
And now, here's the veteran voice of the legal fix, Bruce Buffer.
Ladies and gentlemen, we are live from the Lone Star State in Montgomery County, Texas, for a brand new episode of the Legal Fix, a new age radio show presented by the Tuff Law Firm, the toughest law firm in town, with the toughest lawyers around, answering your toughest legal questions. Introducing first, hosting out of the red corner, the big deal, Bruce Wilson. Tough, joined by Boy Wonder, Brandon Scott Riley, and super lawyer, G.I. Jerome, the Golden Boy, Jeremy Lee Hall.
Hey, thank you, Bruce Buffer. I'm the big deal, Bruce Tuff. I'm here with Daniel Armentor and the Golden Boy, Jeremy Hall. BW's been placed on the PUP list, and we'll keep you updated about his whereabouts. If you have a question, please call the hotline at 936-900-2381.
Hello.
All right. Hey, guys, how are you?
Hey, excellent. How are you? The big deal.
Oh, hell. I was recapping with the Honey Badger the week in review, and I said, who else has a week like this? We had 6 of our lawyers in trial at the same time at the Harris County Courthouse.
6 for 6.
We had one trial starting Monday. It carried over to Tuesday. We had the Tuesday trial carried over, started in the morning. They did tell us it was going to be 1 o'clock, then they moved up to 9.
And here
we
it is,
get about
folks,
24 hours notice. Yeah, that's where we were all hanging out. We were on 3 floors.
Now, this looks like the Taj Mahal. Why would anyone feel uncomfortable here?
It's just beautiful. You know, that's the family courts, one of the family courts. There's plenty of them up there, but they're all on the one. So if you ever have to go to court and you're going to Harris County, it is one court building, and all the courts are located in that building except for the criminal courts. The criminal courts are in there in a separate building, but all the civil courts are in there. But I had all 6 lawyers in trial, and on Tuesday, when we had a break for lunch and we had three trial proceedings going on at one time, we all were in the lunchroom. the Luby's cafeteria at the bottom of the civil courthouse, 201 Caroline, and we were all hanging there with our respective clients, and got a successful trial victory in one of the cases. So BW and Daniel Armentor did a great job.
Congratulations, guys.
I went down and testified to attorney's fees on Tuesday. Jeremy and Paula were in trial for 3 days. Daniel, and I think you guys finished in 2 days, was it, or 3?
No, we finished in 2 days. It felt like 3.
Two for you, 2 for you.
2.
Right?
Yeah.
Okay, so then I had a small meeting with the Department of Homeland Security. Had a few administrative boards that I was on that had meetings during that time. And so this whole week feels like a month, but it's only been 4 days, and here we are on Friday. And we're about ready to move into our new space. So I got the carpets clean, and we're getting the painting done today. So, I mean, we don't slow down.
That's exciting.
What goes on in a meeting with the Department of Homeland Security?
Oh, my God, it's intimidating.
Yeah.
Let me tell you, the Department of Homeland Security does everything. They are the big bad boys of the government.
I've heard.
And they have a consolidation of all the law enforcement agencies. So from immigration, customs, border control, in civil investigations, tariff regulations, national security, and that goes from protecting the president to drug lords to fentanyl to they are the guys. They are. So anytime you're with a federal agency, especially a law enforcement agency, it's intimidating. I don't care how long you've been practicing law and how many times. I've been before investigations with the FBI, the Department of Justice, the Assistant U.S. Attorney, had clients that have been charged with federal crimes, tax fraud claims, bank fraud, criminal violations, banking regulation matters, and every one of those to me, has, I don't feel quite as bad as my client, but I'm apprehensive every time, and I'm very nervous about the outcome because you never know. It's always uncertain. So let me just tell you, all that stuff, you need a good lawyer who's experienced, and you need to have the right lawyer for it. So sometimes, we aren't the right lawyer, but I'll find the right lawyer. But that's it.
And they seek to create that type of intimidating environment.
Well,
that's intentional.
I think it's natural from the
It is.
state, municipal to federal policing agencies. And, I mean, there's a level of professionalism that always spreads out through all of these agencies, and it's very unique to find certain individuals that have that high level of professionalism, that do their job and they don't let it go to their head, and then they become, the character that's portrayed on TV sometimes. So, yeah. But
sometimes you're getting tossed up against the wall.
Yeah, so it's intimidating, man. I'm telling you, you can't. They take your cell phone and put it in a locker. So yeah, I didn't bring it the second
no communication.
time.
No, that's good.
Yeah, it is.
Keep away. You got to play keep away sometimes.
You have to. All right. So what we're going to do is we're going to dedicate this episode to lessons learned from trial, because there's nothing like being in 3 trials in court with evidence on very complicated cases involving someone's property or their money or their children or their liberties. So we had all 4 of those categories this week. We had someone's liberties, property, money, and children, all of them. And we covered it all with the Tough Law Firm. I'm so proud of you guys.
Yeah, thank you.
All right. So what is the big lesson you learned from trial, Jeremy? You were trying a case. You did a lot of cross-examination. Without getting into the particulars of the clients or the type of case you had, what was the lesson you learned?
Yeah, thank you. I think being adaptive and going with the flow in trial. I think sometimes when the referees are letting them play, as they say, letting them play rough, you got to be willing to get physical. And in this case, the judge was letting us go back and forth, tit for tat, and kind of letting us argue it out as long as we wanted to. And so she was letting whoever wanted to have the last word have the last word. And in some cases, it was even creating confusion because she would sustain opposing counsel's objections, but I would have had the last word. So it sounded like she was sustaining me when, in fact, she was ruling against me. So it was that type of Wild West environment. And so leaning into that was something that I really enjoyed. And that's something that you kind of coached me up on, because I think you've done that as well.
I love those kind of trials. I actually enjoy that more because it's such a free flow and everybody can say their piece. The judge hears everything. You're actually talking about evidence. You're actually talking about the matters of the trial. I always feel more comfortable as the attorney. And so when Jeremy talks about the referee, what he's talking about is the judge. So the judge is like the umpire, calls the balls and strikes. I've had judges that say, state your objection, and then it's a speaking objection. It just goes on for 3 minutes, and you're arguing, and then the other person says objection hearsay, and the judge goes overruled. But if you are kept in the boundaries of a strict one-sentence objection, and then the other party responds, and the judge rules, it's a more controlled environment. And I'll tell you when I find that happening most is in jury trials, because you don't allow those speaking objections in a jury trial, because it really is facts, not in evidence. You're testifying as an attorney, so the referee or the judge should stop that type of speaking objection. You were in a judge trial, so everything went.
Bench
it
trial.
was good to go. I love it. I really enjoy doing it that way because I get to say my piece and the other attorney gets to say, and we go for it. What did you learn, Daniel? What was your thoughts?
I think the most important thing I take from it every time is the best thing is to know your case and to know the law. I mean, I know it's kind of cliche or whatnot, maybe the most basic thing you can say as a lawyer or whatnot, but I think it's very important, and it reigns true. You can stand in the pocket, you don't get flustered, and you know what you need whenever you know your case and you know your facts. So make sure you're prepared when you go to trial.
And I will say, having done many, many trials, I never feel totally prepared. Now, I have had some trials where I anticipated every objection, every piece of evidence, every argument, and every fact scenario from every witness, and it was still a surprise to me, but I did anticipate it, and the whole trial went the way I expected it to go. But that's rarely the case, because you always have evidence that's being admitted that you've never seen before. You have argument from counsel
that you've never seen
well,
before?
I mean, you have like,
isn't that unfair surprise?
it is unfair surprise, and you object, surprise and prejudice,
Okay.
but then the lawyer says, well, no, I produced it in discovery. And then so we have these cases that have 15,000 pages of evidence, and they could be 5,000 emails. And then I looked down and I said, did he produce this? And he goes, well, he sent us 15,000 emails. So
Right.
now we're on the scramble trying to
Right.
figure out whether it was a bait stamped email, and then he shows it, and there it's
Right.
got a little bait stamp on it, and I'm going, how did we miss this? Well, we reviewed 15,000 pieces of documents, and one came up that seemed to be critical to his case. Now, how do you respond to that?
Right.
You object to hearsay. You object to the business, not a proper authenticated document.
Whoa, we've
But
gone to war on that a few
you-
times.
You have to be on your feet to object. You
Right,
have to
right.
immediately. And I have found that the best way to do this is have written objections already laid out in front of you for the evidence that is going to be admitted, so that you have that available and you're not just relying on your memory on those. Now, that's the kind of surprise that I always see. I always see something like that. And so in Daniel's trial, I know what he's speaking to is that you have to be prepared to object, because the other side is always going to drop something in, and they're always bringing in something that's extraneous. Even though we knew about that was coming in, we did proper objections. The judge allowed it in. It was another bench trial. The judge says, hey, I'm going to let all this in. I'll give the proper weight to the evidence itself, but I'm going to have it admitted. It's relevant to the case. It may not be properly admitted through evidence by a business record affidavit or an exception to hearsay. And I know I'm talking very technical about all this stuff, but everything is hearsay. Anything that's written down on a piece of paper is hearsay. So you have to qualify as an exception, and hearsay is an out-of-court statement that is now used in court for the proof of the matter asserted. So you have to have exceptions to that, and you can't just have people telling, well, I heard her say that, so she told me that, and she heard it from someone else. That's hearsay on hearsay. So those are objections you make.
Let me ask you this, the big deal, Bruce Tuff, to our listeners out there who may think, okay, well, I could have the best case ever, but then you, as a trial attorney for trial advocacy, have to turn that into a presentation to the court. You have to do that through evidence, the rules of evidence, and through witness testimony.
Right.
And so if you don't have those, if you can't present your evidence, and if you can't put on your witness testimony, then it doesn't matter how good the story is.
And I've had that happen to me, and this is a lesson for all young lawyers. I went to court. I thought I could develop my case based on the pleadings and asking my questions to my witness, and I was very hung up because my witness was very, very poor and did not even understand the nature of the questions I was asking, other than background. On direct. So then I said, didn't you have a conversation with the defendant about this subject matter? And the objection leading. Sustained. I went, oh, okay, all right. Do you remember having a conversation? Objection leading. So I couldn't get a question out that was non-leading, and I was blocked the whole time. So at that point, I discovered there is a catchphrase that you can ask for young lawyers is, what if anything? What if any conversation did you have with the defendant?
Okay.
What at this date or at this time? What if anything? What if? So
What
it's
if?
a good qualifier.
Okay.
It is the best way to do it. So you have to have a default fallback. And another thing that I like to advise is have an outline of the question testimony and check it off. Okay, I gotta hit this cause of action. I gotta hit this second cause of action. I gotta hit this fact scenario. I've got to ask the witness about damages. I've got to ask the witness, what are you asking the court for today, and then get all those proof elements in. So
Right,
it's kind of
right, the
it's a game
must-haves.
plan. It's a game plan. And
Absolutely.
Daniel was talking about staying in the pocket. You got to be in the pocket on this stuff, you know. And then when you start doing end arounds and audibles, you got to be available. You got to have those available. You know, you got to know. You got to have your backup plan. But stick to your game plan. That's what I always do. Stick to the game plan. You may get blocked. You may get penalized, but still go after the same game plan. That's the way to. I suggest the way to do it.
It's nothing like trial experience.
Yeah, it is. So we have for our audience, and we're going to do this in the second segment, it's lessons learned from trial. We're going to go over jury and bench, what is voir dire, exhibits and evidence, opening and closing, examination, and we're going to talk about strategic behavior as well. So those of you that have ever been in a trial or that are curious about it or apprehensive, we're going to cover all those aspects in our second segment. We'll be right back.
Great.
I'm Bruce Tuff, principal of the Tuff Law Firm. We are a full-service law firm serving the greater Woodlands area and the greater Houston area. Contact us at 281-681-0808. We're tough for you.
We all want to protect what we love. And we know that child safety seats and seatbelts save lives. Yet 3 out of 4 kids aren't buckled in correctly. And in 2016, 42% of Texas teens who died in crashes weren't wearing a seatbelt. Don't be a statistic. If you love it, click it. That includes you, too. Buckle up. Every rider, every ride.
Go to youtube.com on your smartphone, tablet, or PC. Subscribe us on YouTube at Radio The Boss 91.1 FM.
Hey, welcome back. If you have any questions, please call us at 936-900-2381. That's the call-in number. I'm here with Golden Boy Jeremy Hall and Daniel Armentor, DA Daniel Armentor, and I'm the big deal Bruce Tuff. Welcome back to the show.
DAAA.
Yay, we're talking about lessons learned from trial, and we're just finished 3 trials in our office for this week, and we thought what it would be is just, hey, let's talk about it and recap. And I'm going to put Jeremy on the hot spot. So Jeremy is really good at cross-examination. He's really good at examining experts. He's really good at cross-examining attorneys. And in the case that we had, Paula was the lead attorney and Jeremy was our expert examination attorney. And so Jeremy was sharing some notes with me, and I said, you know, when you try a case with Paula, Paula has a unique habit of making noises and kind of pinching you or grabbing you. Yeah. And then she passes notes. And the notes are being passed as you're examining.
God, beautiful mind.
You're right. So these notes come, and if you're ever trying a case and you got your co-counsel passing you notes and you're doing a great cross-examination, and then you have to look down and go, partnership under different name before 2020. I go, what the hell does that mean?
That's like one of the simplest ones. I think we did a word count. It was verified by Danielle this morning. There were 24 words.
How about she
on
still
one
gets
Post-it?
She still gets portion of the money.
That's a pretty simple one. I can actually read that one.
Did that break your train of thought, or do you just
always?
Do you flow, or do you just stop?
I have to flow, Bruce. I have to. I'm looking at the judge to kind of see how she's reacting.
Here's one. Page 4, line K. That would be a great one for me.
Yeah,
I would go on the floor right there.
Yeah.
Okay.
I do
Was
get
it
past.
an elbow punch, or was did she just grab you?
No, a lot of times it would be a sticky like in the middle of my workspace, but then I think there's some more polite placement as the trial went along. So it was nice. We learned to work together, but it is a lot because you're asking questions of the witness. Opposing counsel is trying to interfere with you as much as possible, right? Judge is refereeing.
Objecting, asked and answered every time.
Every
Hearsay,
time.
asked and answered.
You know, I don't know if it's just me, but I feel like I get into these back and forth tit for tat where it's just every single question is an objection, and you're just fighting tooth and nail for
lawyers
every
doing
yard.
Their job, Jeremy.
Yeah, it
That's
is.
us doing our job.
It is,
Yeah.
and
you
I
don't want
also
evidence into the case that is going to hurt you, and you do everything you can to keep it out. Everything.
And you could have sat with your client, you could have talked about how incriminating it is or how good it is for your case, but if it doesn't get in, then the court or the jury can't consider it. So it doesn't matter at all. You have to get it in.
Right. Okay.
So these things become very important.
Yeah. Rapid fire questions for you. I'm going to go down our list.
Yes, sir.
Jury versus bench. What's the difference? Jury versus bench.
Well, a jury, you have to pick it first, which is a whole complex exercise in and of itself. Then you have to size up however many it is, 9, 12 members of the jury with a judge.
Six or 12.
6 or
in
12.
County court, 9 in district.
Okay.
Yeah.
And with the judge, you're just pleading your case to one person. It's a little more straightforward. It's a little more clean
Easier.
cut.
It's
a little easier. It is absolutely.
Easier. No
easier.
motion in limine. No restrictions.
Limine, what is that? That sounds like a dessert.
Well, Daniel, do you want to take a shot at it?
Yeah, it's
motion and limine.
And before you make a motion to the court, before the trial gets started, so that you can have evidence excluded in advance, so that you don't interrupt the flow, you don't waste the jury's time, you keep the facts that matter for the trial at hand whenever you're actually going through trial. So if there's anything you can get admitted right away, you want to go ahead and do that early on. That way, it's one less thing you got to worry about, and the trial is maybe you can get it done in one day.
Yeah, maybe like the glove in OJ would be an example. Maybe they would argue about that.
Not, but that wasn't a motion in limine. They actually brought the evidence in. It was brought in. I don't know if they did the objection to the gloves because they had a chain of custody from the gloves. They probably did. Knowing those guys, they objected to it. But here's 2 examples of motion limine. So it's only it applies during a jury trial, and also it applies on questions that you can ask or during the trial. Now, here's a classic example. In a personal injury trial, you can't mention the word insurance. So they limit it out. That means you can never say it. So if the defendant has automobile insurance, you can't say, hey, by the way, I know we're suing this guy right next to us, but he has auto insurance, and really his company's going to pay us once we get a big judgment against him because he's negligent and he knows he is. We can't say that. So that's a motion limine. Let's say that he had a criminal conviction 10 years ago, and and it's a non-moral turpitude crime. We can't talk about that. That's limited out. So even in criminal cases or other cases, it may prejudice the jury.
Right. Oh, he's a bad guy. We're not gonna believe anything he says.
So in voir dire is where you select a jury, and it's a French word, voir dire.
Voir dire is on the East Coast. How I learned it, I come down here, it's voir dire.
Yeah,
it sounds like an illness that Jeff Foxworthy made up.
Voir dire or voir dire?
Came down with a slight case of voir dire. I mean, voir dire is what I was used to, and Maris told me you say that down here, nobody's going to know what you're talking about. So I adopted voir dire.
I used to say both ways, but voir dire just looks like the way it sounds. Yeah, it's Texan. You know what the hell? Do you know what it means? Do you know what voir dire means?
Selection of the jury memberships.
Yeah. How do you pick a jury?
When you're with Bruce Tuff, you pass lips between him and Boy Wonder. And you take. There are 8 to 12, I believe, pieces of information on these little phone callback looking slips that you have.
About an individual.
And then you have how many in front of you?
God,
60, 80 or so?
60 plus.
And now you have this pile of slips, and you have to match them with the individuals.
And ask them a little bit about their background and their history and their bias or their prejudice without insulting them, and give them a little bit of the facts of the case. So you have to go through most of that. And then out of that, you pick a jury, and you have strikes for cause. So if someone has a prejudice against your client, or a natural prejudice from being on the jury, he or she can be struck for cause, and then each side gets 6 preemptory challenges. It could be more, but usually 6 to strike a juror for any reason whatsoever. I don't like him. I don't like the way he looks. He's giving me funny looks. you can strike that person.
Gordy Bunch.
Yeah, strike
for
that person.
cause?
Yeah, for
or
cause.
peremptory?
That is preemptory, but he should be struck for cause. So, yeah, cause strikes are natural prejudice or bias that has been demonstrated during the voir dire. So we did limine, we did how do you pick a jury, then you end up with your 12, and the 12 are selected because they're eliminated through cause, and then they're eliminated through the preemptory challenges. Each side has 6, and then you end up with your 12.
And that whole process can take anywhere from a lightning round in Judge Santini or Bay's 45 minutes to, if we're talking Hardin versus Busby, duking it out for half a day, day. How long do they get?
Yeah, they get a long time.
Okay.
Those guys get a long time. So it depends on the judge, and the judge has total discretion on what would be a reasonable amount to do the voir dire. Now, exhibits and evidence. What do you guys think about that? Anything about surprise, any moment you had that was an aha moment during your trial, Jeremy?
I like to keep track of both sides' exhibits because to me it helps to look at the case as a whole,
right.
Not plaintiff or defendant's exhibits. And so when it comes to pre-trial, I like to bundle those into a sheet, and I like to use those to present my case from both sides. It also helps to have it in a PDF where you can put it together and tab it and go to any exhibit easily up on an overhead. But you have different ways of trying a case. A lot of attorneys don't try cases that way. The eraser, for instance, has paper exhibits.
Right.
And I'm curious, how do you show or present your exhibits at trial?
Well, I like to present them through electronically, Jeremy. When we did our last couple of trials, I had them all displayed. When I was cross-examining the witness, I had Jeremy on the computer, and Jeremy would pop up pre-admitted exhibits during the questioning of the witness, and we had a timing down. And then when I was talking to the witness and I said, hey, would you refer to the overhead, Dr. So-and-so, and just tell me what that exhibit is, please? And it was a natural flow, and that's how I like to do it. Now, if I have to go old school, I'll do the overhead with paper and walk up to the, and I used to use big demographics, blow up boards and posters, and I'd have them sitting right in front of the jury the whole time. So the whole time they're looking at my damage model, or the whole time looking at the contract, the whole time they're looking at a photograph. And I found that to be pretty effective as well. Was there an aha moment for you, Daniel, on exhibits? Anything?
Our case was pretty straightforward. The judge wanted to see it all.
Good. Everything came in?
Yes, everything did. We had things buried in a 500-page exhibit, things here and there, with some sorting out. As far as objections, none got sustained. Everything came in.
Yeah, that's how the judge wanted it. That's okay. All right, now, opening and closing. What's the difference between opening and closing? What do you want to do in that situation, Jeremy?
Opening, I want to tell you where I'm going to go, and then I want to explain it in a little more detail, then I want to summarize it for you. Because I know what I'm going to show. And then in closing, I want to sum it up for you nicely and say, see how I showed you and how this went, how I said it would at the beginning, and be very clear about what I'm asking the judge or jury to do. I also like to do that with visual aids. Like if I've had some stuff that's really hit during the trial, I'll bundle it up and have a highlight reel shown as exhibits during closing.
Good. So tell them what you're going to tell them, and then tell them what you told them.
Yes,
so that's
sir.
a really good model.
Thank you.
All right. Examinations on objections. What's any reactions to objections? You went tit for tat with your opposing counsel and witnesses. You had so many moments in that trial. Anything you want to share with us, Jeremy?
Yeah, I think you learn as you go along. You get trial experience. I have a thing. I say there's no inexperienced trial attorneys. Everyone I've gone up against has been a seasoned veteran. This was no exception. And there are some cases where your line of questioning just gets completely shut down. They say stoned him in hockey, right? Like save, just shut down, move on to the next thing. And so if you're the eraser, right, you have a pad of paper and you have to flip over to the next section and keep going with your exam. If you're me, maybe you're scrolling to the next page. In any case, you have to basically seamlessly transition into the next topic without looking or feeling defeated, even though you just got your game plan blown up in essence, and you have to move on to the next thing. You have to pick up the pieces and keep moving.
You got crowbarred to the gut. Yeah, and you just keep
right.
that stone
Scrape
face.
yourself yourself
Yeah.
up off
Yeah.
the canvas, keep it moving, move on to the next section. Poker face, didn't hurt at all.
Don't chase the mic drop moment.
Yeah,
Don't do it.
and that's something that you taught me, Bruce. Sometimes if a witness is clever enough and they're avoiding saying what you're trying to get them to say or show, it's evident to the judge or the jury, the court, what the witness is doing. You've made your point. Move on.
Right, right. Daniel?
Yeah, I agree.
Yeah.
And I think to add to that, never forget what you're trying to do, depending on what side you're on. You know, if you're running the plaintiff's side, you have a case to prove. You have to stay on track and remember the exact elements that you need proven. And on the other side, you need to keep track of what you're defending. You know, don't go too far off track. Stay in line, and focus helps.
Very good. All right, strategic behavior. Anything about that? This is probably one of the biggest things in trials is strategic behavior. How you are going to behave with the witness. So Jeremy had an opposing counsel was just, a barracuda and didn't care about any strategic behavior, just was going to be, on attack the whole time.
Yeah.
Take no prisoners. But you were polite, and how did you deal with that, Jeremy?
I was. I realized that it was something I need to improve on. Maybe something I need to take to the Lord in prayer. It really frustrates me when people treat me unkindly or disrespect me, and
especially in the courtroom.
In the courtroom, absolutely.
Yeah, like you've done something wrong to them, and now
Yes.
you're their mortal enemy.
And
Most
exactly.
attorneys do that. I've seen a lot of them do
it's
it.
sad.
It is, and I never do it to another attorney. I mean, I've had them just be out and out disrespectful, unprofessional, and rude.
Why?
And that's just the way. Oh, that's just the way they function. It's just like, okay, I got to go in the courtroom, and I hate you, and I hate your client, I hate everybody else, and that's.
I know it'll shake you up.
Yeah,
it's like getting into a pregame fight, just to rattle the other team.
It's just rough.
It's a
but
tactic.
all the attorneys that I go against, I have a level of respect for them because it's such a demanding, hard profession.
Absolutely.
To be a trial attorney, you have to have a special skill set.
We deserve to be kind to each other.
Well, I wish we would. I wish we would, because it doesn't. To me, we're trying to represent our client to our best ability. It doesn't mean that we have to be spiteful and so negative, but that's part of the strategy. Really is.
Mm-hmm. And it's effective. And I realized this was my aha moment, that it was having an effect on me. And so I need to learn how to prepare for that and deal with that.
Okay, so good. Thank you, guys. What a great week this is. We have 4 trials coming up next month, and we have 2 after that, so it looks like there's going to be no let-up for the Tough Law Firm, but we're ready to go, man.
Yes,
this is
sir.
all good. Hey, I want to thank you all for watching The Legal Fix, brought to you by the Tough Law Firm. Call us at 281-681-0808 or visit thetoughLawFirm.net or hit us up on the comments.
Catch past episodes and highlights on our website and YouTube channel. Connect with us on Facebook, Insta, and listen live on Spotify and 91.1 FM, The Boss, Fridays at noon.
All right, I'm the big deal, Bruce Tuff. I'm here with DA Daniel
Yes, sir.
Armentor and the Golden Boy, Jeremy Hall. We'll see you next week on The Legal Fix.
See ya.